Good afternoon and welcome to everyone joining us for this very special webinar on new directions for family drug and alcohol courts. We have representatives here from a wide range of disciplines, including magistrates, members of the judiciary, CAFCAS, local authority, FDAC services, university academics, and many more. That so many people are here illustrates the strong interest in problem-solving courts. Whether FDACs in care proceedings, those relating to criminal or youth justice, or the pilot pathfinder courts in private family law, problem-solving courts are very much on the political agenda, and we look forward to hearing more about this today. I'm Dr. Linda Cusworth, a research fellow in the Centre for Child and Family Justice Research at Lancaster University, and I'm delighted to have been asked to chair this event hosted by the Centre. Established in 2016 and co-directed by Professors Karen Broadhurst and Judith Harwin, the CFJ is host to academics, research staff and students from the departments of sociology and the law school. We have strong policy, practice and community links and regularly welcome international visitors. The overarching aim of the Centre is to inform and improve justice for children, young people and families, and our research spans family, youth and criminal justice. Employing a diverse range of theoretically informed qualitative and quantitative methods, including innovative large-scale data linkage and survey methods, co-design and participatory approaches, current research projects in the Centre include the following. The co-produced Hope Box intervention, designed to support women separated from their baby close to birth due to safeguarding concerns. The Routes Through Court project, which is investigating different journeys that families take through private law proceedings. Keeping Mothers in Mind, which is seeking to understand the mental health needs of mothers who have children removed through the family courts. A data linkage study investigating the impact of family drug and alcohol courts on parental offending, which we'll hear more about today. And Permanently Progressing, a longitudinal mixed method study investigating the pathways, experiences and well-being of a cohort of children who became looked after in Scotland when they were aged 5 or under. You can find out more about all these projects and our other work on the CFJ website. We have a fantastic lineup for you this afternoon with 3 really exciting presentations. We're also delighted to be joined today by Lord Justice Peter Jackson, Lord Justice of Appeal and Lead Judge for Family Drug and Alcohol Courts. Lord Justice Jackson will conclude our event with some reflections on current judicial thinking around FDAC. I'd now like to introduce our first speaker, Professor Judith Harwin. Judith is a professor in socio-legal studies at Lancaster University and co-directs the Centre for Child and Family Justice Research. Carrying out research for more than 30 years on vulnerable children and families, she has a particular interest in family reunification, outcomes for children in public care, the role of the court, and the potential of problem-solving courts. You can find more information about Judith's current research projects on the Centre website, and we'll put the link in the chat. Judith's presentation is entitled, What We Know About FDACs and What We Need to Know. Judith, if you want to share your slides, over to you.
Thank you very much, Linda. So, my talk today is going to be focusing on what we know in terms of the research evidence and what we need to know. Before I talk about the research evidence, I thought it was important to very briefly outline the key features of FDAC and how it differs from standard care proceedings. So FDAC is a problem-solving approach to care proceedings, initially set up to deal with parental substance misuse as a key factor, but also nowadays as a contributing factor. The key difference from ordinary care proceedings is that the court, as well as adjudicating, provides intensive support during the proceedings. That's its radical difference from ordinary proceedings. To achieve that goal, there are 2 key mechanisms. The first is the judge-led review hearings with parents. The key feature is that there are no lawyers present. The Judge is assisted by a multidisciplinary team who advise the court and supports parents, both in terms of providing direct support, but also linking parents into community services. The central goal is to reunite, but that is not always possible. And when it isn't, then the aim is to make timely decisions about alternative care for the child. FDAC started now a long time ago in 2008. And as you can see from the figures here, it's now operating within 21 courts, 37 local authorities, and there are 13 FDAC specialist teams. So let's now look at the research evidence. What do we know? The outstanding main finding is that reunification and parental substance misuse cessation rates are, as I put on this slide, significantly higher at the end of FDAC compared to non-FDAC care proceedings. This is found in earlier studies, in the most recent report by NatSen, and it is also achieved in international studies, mostly dealing with American equivalent courts. I will have put here for you the links so that if you're interested in following these studies up in more detail, you're welcome to do so later on. But the key point is that it is a consistent finding and has undoubtedly underpinned or helped contribute to the development of FDACs. The issue now is where we need more evidence. We certainly need more evidence on the sustainability of reunification and substance misuse cessation. It's a huge achievement that families coming in with such significant problems at the start of a care case can manage to overcome their difficulties with the support of FDAC. But it is essential that we know how well those positive outcomes endure. Another key issue which stares one in the face when you look at the care proceedings and the profile of cases is the extent of domestic abuse. Similarly, mental health problems are also significant. The last point I would put here is around parental offending, and this is the issue that I now want to talk about, because the reality is there's been really very little information about the extent of parental offending. So we carried out, as part of our studies into the London FDAC and how it compared with other London authorities, we were able to get some information together with the support of the Ministry of Justice on the extent of parental offending in care proceedings. I only want you to look at the top two bullet points, which are in orange, and they make very clear we were really quite shocked to find that over 2/3 of the mothers and fathers in the care proceedings, all care proceeding cases, had a previous conviction. That is a very high figure. And equally, it was notable the extent to which convictions continued after the proceedings had completed. That was one of the drivers to us undertaking the research which we are now currently engaged in. I'm afraid it's got a very lengthy title, but it says exactly what we are doing. So what are we doing? Well, the study has three main aims. The first one is, and this is really the overarching aim, is to see whether receipt of FDAC does make a difference and bring about improvements in relation to maternal and paternal offending and reoffending. We're careful in our wording, and that we say is associated with changes. We're not looking for causal explanations here. We then, related to this, want to pick up on the earlier point that I made about the importance of sustainability of family reunification. But what will be distinctive in this study is that we will be looking at reunification when we have taken into account offending profiles, histories, etc. And finally, the third aim, which is more of a research aim, is that to achieve aims 1 and 2, we have had to create a brand new longitudinal cohort of families. And this cohort will enable us to address aims 1 and 2, but it will also tell us a lot about how far there is an alliance and harmonisation as between information provided in the family court setting and in the criminal court. So we hope to be able to report on that as well. Very briefly then, to the next slide, the main point I want to make from this is that this is a big study. You can see for FDAC cases, we've got 545. And on the right-hand side, it may come as a bit of a surprise why on earth we've got over 2,000. There are good reasons for that, and essentially they are research-led and they are to increase the likelihood of being able to match the FDAC and comparison CAFCAS cases on care proceedings. We've got 7 participating FDAC sites. It's a 2-year follow-up and we'll report next year. I can't wait to find out what the study is going to tell us. However, a study of this sort cannot explain the reasons and the inputs as to the outcomes. So for this, we felt we needed to do a related qualitative study. This study is meant to complement the quantitative study. And what it's going to provide us with is a good description of how FDAC and non-FDAC care proceedings seek to work when parental substance misuse, domestic abuse and parental offending are involved, either as single or as several holistic issues occurring together. We're also interested in the way in which the family and the criminals court work together. And to get information on these issues, we will be interviewing, subject to ethical approvals and judicial approval, we will be interviewing judges, parents, and getting professional perspectives on the contribution of FDAC and how well the family and criminal courts are working together. And that will lead into making recommendations. I want to pull all this together because what I want to do is to look a little bit, very briefly, at what the opportunities are and what the challenges are in carrying out the research programme that I've set out. So firstly, as Linda mentioned, there's high policy interest in problem-solving courts, whether they're within the family justice or the criminal justice system. We know that the FDAC approach can be replicated. The recent NatSen research has made that very clear. They involved 13 FDAC sites and they had positive results about reunification, just as the earlier London sites had. We know that also the holistic approach lends itself very well to addressing co-occurring problems. That is its strength. And undoubtedly, the fact that FDAC does have a strong theoretical underpinning, particularly related to procedural justice, but also to what's called therapeutic jurisprudence and ways of motivating families, is very helpful as a potential explanatory framework. There are undoubtedly new green shoots. There's new cross-jurisdictional guidance, a new protocol that came out earlier this year on the ways in which information can be shared as between the family and the criminal courts. And likewise, care proceedings applications now do log domestic abuse and interpersonal violence. And that is all very encouraging. But we can't underestimate the challenges. And the first and most obvious one is around the sustainability of FDACs due to resource pressures. Some FDACs have closed, and whilst others open, this is undoubtedly a main pressure. Programme evaluation is also a challenge. It's always complex, but we know that we cannot carry out random control trials in FDAC. And often an additional problematic factor is that the descriptions of service inputs and the outcomes at the end of the case in all care proceedings are often missing, but they're vital. We need to know whether families do attend the services that are offered. And equally, we need to know which problems compared to baseline have been addressed and which remain problematic. We know that FDAC cases haven't been consistently flagged on CAFCAS and MOJ databases, and that makes it difficult to routinely track them. They're often invisible within the system. So we can't track these cases just from the administrative databases. We've got a project ongoing at the moment in conjunction with the Centre for Justice Innovation, where we are trying to evaluate the availability of FDAC data and its quality and see if it can be used for future research. It's got a rather dramatic name, the FDAC Data Rescue Project. So I want to finish by thanking the wonderful teams that I work with. Here are their names and details. And finally, warm thanks to you all for listening to this presentation today.
Thank you, Judith, for that really informative presentation. Such a lot of important research going on, and obviously lots more work to do. I'd now like to introduce our next speakers, Helen Fox and Fiona Deacon. Helen is a solicitor and has been the Magistrates Court legal advisor for more than 30 years, advising in all jurisdictions of the court over that time, including the Family Court. She's been a legal advisor to the problem-solving justices for 9 years and established one of the early Greater Manchester problem-solving courts. Fiona is a senior probation officer and the strategic lead for women within Greater Manchester. Fiona joined the service in 2008 and soon focused on the experiences of women in the criminal justice system. She worked in a number of roles as a practitioner in learning and development and as a practitioner's manager, but kept a focus on alternatives to custody for women and developed the Women's Problem Solving Court in 2014. The Greater Manchester Problem Solving Court for Women is the theme of Helen and Fiona's presentation, and I hand over to you now. Thank you.
Brilliant. Thank you so much for that and for that introduction, which means that we can swiftly and promptly move into the presentation. I assume you can see the slides. I know Helen would tell me if that wasn't the case. So we are here to represent the Women's Problem Solving Court approach, which is a similar approach in many aspects to FDAC, but it sits within the criminal justice system itself. And it's been in operation now for 10 years. We're in our 10th year. Okay, so I'm going to start with a bit of a focus on why women. And quite simply, the fact is that the majority of women in the criminal justice system are victims first, with much worse offences committed against them than they go on to commit. The majority of the women that are in prison are not a risk to others, but quite often a risk to themselves. So it's quite a complicated landscape supporting women who are also committing offences. Women are a minority group within the criminal justice system, albeit 51% of the general population. So that's always a bit of an odd statistic. But then within this group, we have minority groups. We know women who are doubly disadvantaged, who have multiple unmet needs, but also women are disproportionately overrepresented as well, such as young Black women. So my experience of all of this as a practitioner navigating the criminal justice system led me to conclude that we needed to change our approach. and also to look to address the social needs, the view of a woman's place in society, their experience of violence against women and girls, but also look to address the needs that underlie the criminal behaviour, which is the reason why we meet them. So I led on the development of the Women's Problem Solving Court within Manchester and Salford Magistrates Court in 2014 as an alternative sentence for the criminal courts, with the ultimate aim to reduce short custodial sentences and look to address the root causes of crime. I wasn't completely maverick and going at it alone. There's a whole host of research, strategies, papers, policies that support the need to have a different approach. All roads lead back to Baroness Corston, but I'm very aware that at that time, many practitioners were thinking, you know, we need to do something different here. The experience of a woman in the criminal justice system is very different to a man. So this will be shared with you later in case you want to have a look at any of these further, but I just thought it'd be helpful to outline the kind of history that goes alongside this. So thinking a bit about the gendered pathways and some of the trends that we see in the women that we meet, and having observed FDAC proceedings, there are so many crossovers with the parents. Obviously, I'm thinking particularly the mothers, but particularly in terms of the social and economic context. So many people that we work with will be the primary carer of dependent children. Many women are victims of abuse, and quite often their offence can be linked to that abuse as well. And it might be that it's not very clear to the woman at the time that some of this behaviour is maybe under duress. Substances use, so obviously FDAC court, big focus there on substance use. We know that a lot of the women that we work with heavily rely on substances, and it is a coping mechanism. It's a way of surviving and coping with past trauma. So you definitely see those crossovers there. And then generally health inequalities, a lot of depression, a lot of anxiety, a lot of trying to support the woman to get out into her local community and find her identity, who she used to be. Obviously thinking about the sentencing trends, it's slightly different for us. We're criminal justice focused, but we do see an overrepresentation of women serving short custodial sentences for non-violent offences. So focusing a bit more on sentencing trends, and this is something that the problem solving court directly looked to address and still does. So in terms of custody and remand, for example, there's a strong argument to save imprisonment for those custody is inevitable cases for public protection. There's also a bit more to consider when thinking about women. So there's the impact of maternal imprisonment for one, and the huge links between intergenerational offending. But also women's prisons are very spread out. There are 106 male prisons in the estate, and there are 12 women's prisons. So I'm based in Greater Manchester. We've got one not too far, which is great, but not all women go there or stay there. And in direct comparison, there are no prisons for women in Wales. So as a Welsh woman, if I was sent to prison, I'd also be sent to another country. The children of that woman have maybe a 200-mile round trip to maintain their relationship. So that is hopefully a strong argument as to why we focused on women. And I'm going to hand over to Helen now for an explanation on how the problem solving court operates itself.
Thanks, Fiona. So the Greater Manchester Women's Problem Solving Court is a sentence of the Criminal Court for adult women who reside in Manchester. It's carried out under rehabilitation activity days as part of either a community order or a requirement of a suspended prison sentence. Regular reviews of the order take place before a specialist panel of problem-solving magistrates, and additional support is offered to the women who are subject to this sentence in order to address the issues that are the underlying cause of offending. The criteria for eligibility is on the screen. The reason they need to be a female resident of Greater Manchester is the extra support is for Greater Manchester residents at the Greater Manchester Women's Centres, which is funded by the Mayor's Office and others. Fiona will explain in a bit more detail about the wonderful work they do. The problem solving court originated in the Magistrates Court, but over time the Crown Court judges have been briefed on this sentence option. So we also now have a significant number of women who were sentenced in the Crown Court, but the reviews take place before the magistrates as we have a system and a panel set up for the reviews. As you can see, it's risk of custody or medium to high community sentence. It is an onerous order, and as such, it's reserved for more serious cases. It's a viable alternative to immediate custody, and a number of the women subject to women's problem solving are on suspended sentence orders. Participation in this court can be the reason they didn't immediately get sent to custody. The third criteria is multiple complex needs, and there's a list there that is by no means exhaustive. As you'll be aware, often if a woman, for example, presents with addiction, inevitably a number of other issues will follow. These issues are always connected to the reason for offending. So the whole premise of the problem-solving approach is if we can resolve the underlying problem, then offending can either be reduced or stopped. The women do have to be motivated to address their problems. As I've mentioned, it is an onerous order, and although a lot of help and support is available, they have to be willing to make that change. If they're not able or willing to do so at this stage in their lives, then this would not be an appropriate sentence for them. So the cohort of women, some facts and figures here. Currently, we have around 120 women subjected to this order. 30% of them were sentenced in the Crown Court and the remaining 70% in the Magistrates' Court. Most of the offending we see is acquisitive crime or it's alcohol related, and the majority of the women are repeat offenders. We have noticed an increase in convictions for charges of assault on emergency workers over the last few years. The women that we see report with the highest needs, which really reflects what Judith was saying earlier, emotional well-being, accommodation, substance misuse, domestic abuse and health issues. So they are the people that you're likely to see in the FDAC court. We have a panel of magistrates and a review process. So a committed specialist panel of lay magistrates. There are over 800 magistrates in Greater Manchester, just 27 sit on these reviews. They're specially trained and they have an interest in a problem-solving approach. They meet with the women to discuss their progress every 6 weeks. And like FDAC, no lawyers are present. The reviews are incredibly informal and relaxed, not like court as you would know it. A report's prepared by the probation practitioner, and that forms the basis of the discussion. The magistrates ask the women how the order's going, and they get them to reflect on their progress and offer advice and encouragement. They will agree realistic goals to be achieved before the next review. If the order's not being fully complied with, the magistrates may get the woman to reflect on the possible consequences of failing to comply and provide advice and encourage them to re-engage. And this can actually be really effective, and we do see them re-engage following that discussion. The feedback we receive from the women about the reviews is usually very positive. They feel the magistrates are on their side and they don't want to disappoint them. So for several years, all our reviews took place in court, but as a result of the COVID restrictions, we trialled digital reviews. The women on the order attend at the Women's Centre and they link in on CVP or Teams to the magistrate sitting in court. And the feedback from that's been really positive, less travelling, a more comfortable surroundings, there's help available at the Women's Centre if they're in crisis. So as a result, the panel agreed a hybrid approach, some reviews in person, others digitally. The first one's usually in person to sort of set the ground and explain the process. And the last one is hopefully a celebration of success. And it's really wonderful to follow the women through the process and see the positive change in their lives. They get presented with a certificate at the end, and it's quite special to be at that hearing. The magistrates who sit on the reviews have had training in trauma, and they do adopt a trauma-informed approach to the reviews, encompassing the 5 principles of being trauma-informed: trustworthiness, empowerment, safety, choice and collaboration. Hopefully, if you were to watch one of our review courts, you would see those principles adhered to. And we're currently taking part in an academic study by Leeds Trinity University titled A Trauma-Informed Evaluation of Women's Problem-Solving Courts. So we're really interested to see the outcome of that study. Fiona, I think you're going to talk next.
Yeah, fab, thank you. Yeah, I can't really speak highly enough about the women's centres. They are there for any woman, not just women in the criminal justice system. And I don't think that's so obvious when we talk about them, because actually many people don't know they exist. It's a need to know basis. So we've got a really strong network of women's centres across Greater Manchester. They're managed by 9 providers, but they cover all of the regions, and they're supported by the combined authority, which is our local authority, but they are independent centres as well. They've all come together to form an alliance. So that's sort of the background, because that's quite a different model than other areas have. But where we benefit is that they will work with any woman. So we refer women directly there when they're on probation, whether they're on problem-solving court or not. But as Helen said, there's so many additional benefits like remote dial-ins directly to the court from a safe place. And then the woman can continue to go there after probation. So it really then lends itself to that non-statutory support. They'll build a relationship with a support worker who doesn't represent probation or children's services or the police, and they will gain all the support around those social needs that were there before we met them. So that's kind of really the backbone of everything that we do. Helen, over to you.
So just to discuss our links with FDAC, District Judge Crisp, who's a Greater Manchester FDAC judge, had a case in her court where a woman was participating in FDAC, but she was also given the women's problem-solving sentence and had to attend our reviews. So she made contact and was able to give an explanation about the commitment required by the women on FDAC. She provided her view that further court reviews may impact on the ability of the woman to fully commit to the FDAC process. She explained it's incredibly intensive, involves 3 weekly testing, attendance at key work sessions twice weekly, attendance at family time, and fortnightly attendance at court. That's in addition to completing the criminal court order. The panel were advised that the reviews cover many of the same issues that we would discuss in any event, and as a result, they agreed that our reviews could be suspended while the FDAC process was continuing. As it's a criminal court order, the work on the order can't be suspended, it has to be completed. It's simply the reviews that are suspended. Once the FDAC process is complete, the women's problem-solving reviews will resume if the order is still in force at that time. So following that connection, we arranged some visits for all the justices, and I've been myself, to watch the FDAC reviews, which we've all found really interesting and useful. Having observed the depth and detail of the reviews, it's cemented the approval to suspend the women's problem-solving reviews while FDAC's ongoing. We're also pleased that His Honour Judge Barclay, who you'll be hearing from later, has agreed to be our speaker at the next panel meeting, and he's going to talk to our panel about the problem-solving approach taken in FDAC cases. So I think it's really useful to have that connection between the two courts, as each court adopts a problem-solving approach with a view to achieving a positive outcome from the court process. Fiona, next steps.
Brill, yeah, I'll keep this brief because we're in an election period and I understand that's what I'm supposed to do. So in 2020, there was a white paper produced in terms of a smarter approach, and the problem-solving court itself was identified as a way forward within the criminal justice system, but also reflecting on FDAC and other similar models out there. So off the back of that, there were MOJ pilot opportunities, and Merseyside, Teesside and Birmingham were successful in applying for a pilot to run their own problem-solving court, which was then, as it developed, renamed as an ISC, which is the Intensive Supervision Court. The Birmingham one is also focused on women, and with Merseyside and Teesside, the focus is substances. So now that they're coming out of that pilot, we're looking to firm up those relationships, share our learning, and similarly to FDAC in Greater Manchester, just keep each other updated and support our ways of evolving, because we always have to evolve. I mean, you know, we will really benefit from learning from each other as well, particularly as FDAC continues to grow. And then just to note as well, it was acknowledged in the recent HMIP thematic inspection that was published in May that the Women's Problem Solving Court is an area of effective practice. So there are more of us out there, whether we're called FDAC or ISC or PSC, we're all offering a very similar person-centred approach to proceedings, just bringing someone into that. And other areas can do this, and we would always offer that support. So just to back that, we've got a bit of data for you.
So as you can see from the proven reoffending rates, Greater Manchester has lower rates consistently than the national average and is notably lower than other metropolitan areas, particularly those with similar socio-economic backgrounds such as Merseyside and West Yorkshire. The figures are there for you to look at, and they're available from the MOJ. After the first year of the initial Women's Problem Solving Court, a cost-benefit analysis was carried out, and Fiona, who was involved in setting up that very first court, is going to explain that to you.
So yes, huge savings in terms of socioeconomic savings. So it doesn't feel like a tangible saving for us. However, we recognise that if you were to opt for the problem-solving court approach, socioeconomic savings show for every £1 invested, it's a £17.60 saving. So it's broad, it's thinking about women going to prison and the cost of that, it's children being removed, it's the woman attending A&E intoxicated on a Saturday night, the mental health services are quite broad but real, something to kind of really stands out. And then our successful completions, not every single woman will get through this. It won't sometimes be the right time. Women will be breached. They may have suspended sentence orders activated. They may continue to offend, but we're always hovering around the 60% successful completion mark, which for a cohort of people with multiple needs is actually really successful. So just going to end on the quotes that you see in front of you there, the bottom two being women who are part of the Women's Problem Solving Court currently, who've provided these quotes, and the top two women who use the Women's Centre, and some of them have been going there for years, some of them will continue to go for years. Yes, I just wanted to leave that with you, and thank you very much for your time.
Thank you, Fiona and Helen, for your presentation. Really inspirational work going on in Greater Manchester. It's great. I encourage people to put any questions you may have for any of our speakers into the Q&A, and we will come back to them after all presentations. Our third and final presentation comes from Vicki Morris and Stephen Whitehead from the Centre for Justice Innovation. Vicki is Deputy Director of the Centre for Justice Innovation. Since 2019, the Centre has provided national support and oversight for new and existing family drug and alcohol courts, a programme of work that Vicki has overseen. As Head of Evidence and Data, Stephen leads the Centre for Justice Innovation's research team, ensuring that their work is rigorous and provides insights that can have a real impact. He's written extensively about the use of problem-solving courts in the criminal and family systems, as well as the use of non-custodial sentences and out-of-court resolution, effective practices in supporting vulnerable women, and substance misuse treatment. Stephen and Vicki are going to present to us now on family drug and alcohol courts, costs and cost benefits. Over to you. Thank you.
Thanks, Linda. And I think my colleague Stephen is going to share slides. So just whilst he's pulling those up, as Linda was saying, so we provide, at the Centre for Justice Innovation, we provide the central national support to all family drug and alcohol court services, including areas that are interested in setting up an FDAC service. And I'm sure my colleague Sophie can put in the Q&A contact details if anybody wants to reach out to us to find out further information or to be linked up with their local FDAC service. So as Judith outlined right at the very start, family drug and alcohol courts, or FDAC, are a specialist alternative approach to care proceedings, so where a local authority are bringing a case to court to consider whether or not children can remain in the care of their parents. And FDAC follows the public law outline as usual, but it has a few key distinct features to it. Predominantly, these differences are that there is a specialist multidisciplinary team of experts who are providing this expert dynamic assessment of the family, predominantly the parents. They're developing an intervention plan, and they're undertaking therapeutic intervention work and regular drug testing with parents, and then reporting that back regularly to the court as independent experts. And in addition to that team, there is a specially trained FDAC judge. They hear the case from start to finish, and that judge will meet regularly with the parents, with the key worker and the child's social worker and guardian as well, in progress review meetings, which are known as non-lawyer reviews, and they take place every fortnight. And during the non-lawyer reviews, that's an opportunity for the judge to implement some of those skills that they've learned around being trauma informed and around motivational interviewing and such, to speak directly with parents around what progress has been happening or not over the past 2 weeks. And there's lots of research which Judith touched upon, and we will put some of the links to that in there. But we know that that element around the judge is really key to families and parents feeling like they're able to open up and talk around the progress that they're making and have their opinions and voices heard within court as well. So like I said, if anyone wants to find out more information about FDACs, we'll put contact details in the chat. So Stephen and I were originally going to be presenting on a new cost benefit analysis and business case that we undertook with our partners Mutual Ventures. However, this research was funded by the Department for Education, and because we are in an election period, so because it's PERDA, we're not able to share the specific findings with you today. Once the election has concluded, we will be launching that business case, and some people may have been signed up to the original launch when that was, and we've had to postpone, but we will let everyone know here around the details around that once it's reorganised after the election. So, although we can't share the specific figures from this particular study, the work builds on the existing evidence base and previous cost-benefit analyses. And so Stephen, when he talks, is going to talk around where there are cashable savings and cost differences in FDAC proceedings compared to normal proceedings. However, before Stephen gets into that, I think it's probably helpful to quickly highlight to you what we know about the cost of non-FDAC care proceedings or sort of traditional care proceedings. So, as we know, care proceedings where local authorities are applying to the courts around looking to potentially permanently remove children from the care of parents represent the most serious and resource-intensive child protection intervention. And it's estimated that the total cost of care proceedings to the state each year is 1.2 billion, with a single public law case costing on average a local authority 120,000. So these figures are taken from the independent review of children's social care. And those figures represent 10% of all direct annual expenditure on the children's social care system. As well, with increased numbers of children entering care and growing costs of care placements, that's really intensifying the financial pressure. So across England, for example, spending on children's services increased by 800 million in 2021-2022, which was an 8% increase from the previous year. When you put in with that the well-documented court backlogs and that increasing average duration of care proceedings, which is far exceeding the 26-week statutory limit, that's a further factor that's exacerbating the cost to the state. And in addition to their high cost, we know that there's a detrimental impact of the care system on children, and the long-standing trauma that is experienced by families in care proceedings is well evidenced. So I won't go into too much detail, but research indicates that parents in proceedings have experienced significant and multiple adverse experiences in their own childhoods, and a high number have themselves been in the care system as children. Adverse experiences in childhood, as we know, increase the likelihood of poor outcomes in adulthood in relation to health, mental health, substance use, and substance use is rarely a standalone issue impacting children in care proceedings. As we said, poor mental health, domestic abuse, neglect are common factors. And many families in care proceedings face problems with housing, poverty, economic instability, and that's made all the more acute in a period with increased costs of living. So yeah, even going through the intensive intervention of care proceedings does not prevent families from experiencing similar interventions in the future, and a significant number of parents return to court, often repeatedly, in recurrent care proceedings, which are estimated to make up about 20% of all public law cases. And so part of the ambition of the late District Judge Nick Crichton, when he spearheaded the pilot of FDAC in 2008, was because I think it was the 8th child from the same mother that he'd removed, and felt that there had to be a more effective way of supporting her and her family and breaking this cycle of repeatedly removing children from her care. And so fast forward 15 years later, after FDAC has been implemented, and I'll hand over to you, Stephen, to talk around where we know some of those savings can be made from outcomes.
Thanks, Vicki. Can I just check, can you see the slides?
Yeah.
Yes.
Great. Okay, so as Vicki says, we're at a slightly awkward time. Like the summer plans of many MPs, our release schedule for the business case was really thrown off by the early elections. So we can't actually share with you exactly how much money we think FDAC saves in total, But what we can do today is we can take you through some of the key outcomes that we know from FDAC and look at how they are linked to cost savings. And I think, thinking about what Vicki said, I think, one of the things we can take away from that contextual information is families going through care proceedings is an incredibly expensive intervention, both in terms of the proceeding itself and then where children end up in care. We know that we're talking tens or hundreds of thousands of pounds to care for them. So there's a real potential for a intervention like FDAC, which changes the way those care proceedings are done and improves outcomes to make really significant savings, and in particular make significant savings to local authorities. So what we have here is a map of what those savings are, and this is sort of fairly parsimonious. We're looking here really specifically at almost entirely cashable savings, almost entirely linked to local authority. There are many other potential outcomes to FDAC, in terms of long-term life course improvements for children and families, people re-entering employment. But we focus really here on the most immediate, measurable, and financially important outcomes. So what we can see here is a kind of a map of these. And in terms of inputs, we're relatively simple. The big additional spend for local authorities is the FDAC team. So that's this multidisciplinary team of social workers, substance misuse workers, domestic abuse specialists who provide the additional intensive support to families who are in FDAC. And we think that costs about £18,000 per case, which is quite a lot, but as we'll see in context, potentially not that much. In addition, as Vicki says, FDAC cases are heard differently. They have regular reviews of lawyers, but we don't really see an additional cost there because as we'll talk about later, the overall number of hearings is lower. That's sort of better understood as a reallocation of resources rather than additional cost. The main cost is to the local authorities rather than to the court service. And here we can see the outcomes, and you can see in terms of how the cases go, we can see they're resolved in fewer hearings with fewer expert witnesses and fewer contested final hearings. We see that there are better outcomes for children in that they're more likely to return to parents, and that children who are returned home are then less likely to return to court. And in terms of parents, we know that they're more likely to stop using drugs and alcohol. So that equates to reduced legal costs for local authorities, but also for legal aid, reduced costs in care, and reduced health and social costs, care costs. So to look at these legal costs in a bit more detail, I want to take you through also, Judith earlier on alluded to some of the evidence that's available around FDAC, and I'm going to try and illustrate where these findings come from as well. So first of all, FDAC cases seem to be resolved within fewer hearings. This is actually part of the work we're doing on the new business case with the financial consultancy Mutual Ventures. They've done some engagement with FDAC sites as well as with building on their previous work looking at how normal care proceedings run. And our estimate there is that FDAC cases typically take around 3 hearings in addition to potentially a contested final hearing, as opposed to 6 in the standard proceedings. And we know each of those hearings might cost in legal fees alone £500 for the local authority, maybe as much as £2,300 if they're using barristers. So eliminating 3 of those immediately starts to pick up a significant saving. Secondly, FDAC cases use fewer expert witnesses. FDAC teams, as well as supporting parents, they do a lot of monitoring their progress and reporting that back to the judge and the court in a sort of form of dynamic assessment, which not only effective, but means you're not bringing in additional experts at an additional cost. In the NatSen study, and this is something that I referred to a lot, this is a study published last year by the National Centre for Social Research and Foundations, which looked at a really large sample of FDAC cases compared to similar cases in normal care proceedings. And they found that only 8% of the FDAC cases used external paid for expert witnesses, compared to 96% of the comparison cases. And each of those witnesses would have cost around £1,200, so another saving there. Thirdly, as we said, cases are less likely to feature contested final hearings. In FDAC, the process of open discussion and engagement between parents, the team, and the judges means that parents will often expect and understand the decision that the court is making, even when that decision doesn't go in their favour. They will be given sort of clear targets or things that they would need to achieve to be safely able to take care of their children, and the open discussion means that they would have a kind of understanding of how far they've come to achieve those. Not, I mean, those are targets is perhaps the wrong word, but they would certainly know what would need to happen. And so as a result, we see that only 4% of FDAC cases end in a final hearing where parents contest the court's decision. And that's compared to, well, NAT7 found 24% of cases in standard proceedings, but I actually think that's a pretty large underestimate. I think those of you who are kind of working in care proceedings, perhaps think about your own experiences. But even so, that would be 20% of cases avoiding a contested final hearing, which might cost up to £3,650 if the local authorities are using barristers. And then, and this is a little bit further down the line, there's some great work that Judith's done a little while ago looking at cases in London compared to standard care proceedings, and found that parents reunited through FDAC are less likely to experience disruption, including returning to court, than parents reunited through standard proceedings. I think it was 34 against 55% within 5 years of the end of their case. And those are potentially very big savings, because each return to court would again trigger like the full cost of a new court case, which one figure is £120,000, another figure is £80,000. Actually, it's very difficult to say how much those cost, but we do know that they're extraordinarily expensive. So there's a major saving there if you could avoid subsequent cases. And then we come on to the reduced costs of care, and this is really where, without wanting to disclose things that we can't share yet, the biggest potential savings for FDAC are, we know that children whose cases are heard in FDAC are much more likely to return to their parents than similar children in standard proceedings. In the NatSen study, 52% of FDAC children will return to parents compared to 13% of parents in standard proceedings. And that's a potentially really big saving. Some of those will have been in foster care placements, which cost an average of £46,000 a year, and could be in those placements several years. A small but notable number may have been in residential placements, which may cost over £300,000 a year. And even those who are in kind of special guardianship, who are kind of living with other family members, will still have a kind of significant cost to local authority, and they may be in those circumstances for many years. So there's really big savings to be made about keeping children out of the care system and with their parents. And then, as we say, children return home and are likely to return to court, and that means they're less likely to drop into the care system at a later date, with again potentially big savings. Finally, the smallest area of savings, but one that's really important to note, is that we know that parents in FDAC are more likely to desist from using drugs and alcohol over the course of proceedings than those in standard proceedings. The NatSim study again found that 33% of FDAC parents had stopped misusing substances by the end of proceedings, compared to only 8% of those parents in standard proceedings. And those ongoing substance misuse imposes a real cost on the state. One person misusing drugs costs £4,700 a year in criminal justice costs if they're offending to support their habit, and in health and social care costs. And a person misusing alcohol costs £2,500 a year in treatment costs. So again, moving people out of substance misuse, as FDAC, the evidence suggests, creates really significant savings. So, as I say, our new analysis isn't quite yet ready to be shared, although we'll make sure that you receive notification when it's available. So I wanted to refer back to something we did a little while ago. An earlier analysis in 2021 suggests that a typical FDAC team costs around £530,000 a year. That's seeing 30 cases. But in its first year alone, in this analysis, it pays back all of that cost in reduced legal fees, and then also offers a £270,000 of additional savings. So even within the scope of the case, it's saving money. And then over 5 years of those families continuing to have care of their children with less disruption, you see the net savings for a team go up to around £800,000 on top of paying for the cost of the team. So that's a kind of, and we'll look to update that with the new evidence, but that's the sort of savings that you might see from an FDAC, and that's pretty much all cashable savings that accrue to local authorities. And here's some sources. We'll make sure you get these slides so you can check those later. I think that's it from me.
Thank you so much, Vicki and Stephen, for sharing some really complex information there in such a clear way. Really enjoyed your presentation. To conclude our event, I'm delighted to invite Lord Justice Peter Jackson, who's lead judge for FDAC, to share some reflections on current judicial thinking around family drug and alcohol courts. Over to you. Thank you.
Thank you very much, Linda. Thank you, everybody. There are, I think, something like 60 judges are currently working in FDACs around the country. And I have, for the last 9 months, been the lead judge, and uniquely amongst all the judges who are allocated to FDAC, because I've never actually been in an FDAC court as judge. I've been able to see a number in action. But from my perspective, despite not having been a hands-on FDAC judge, the overall picture seems pretty clear. The concept of FDAC is probably the most evidence-based court system that we have. In tribute to Lancaster University and to Judith and her colleagues in particular, FDAC has been studied, it's been restudied, it's been validated, it's been revalidated repeatedly during the course of the 16 years that it's so far been running. And although there is always more important information that can be gained, particularly through research and by data collection, which the court system is in general quite poor at, that really the only conceptual uncertainty, to my mind, is just how far it could be taken, what areas it might extend into, how successful it can show itself to be, not only in relation to drugs and alcohol, but also to domestic abuse, and how many connections it can make with successful initiatives such as the Women's Problem Solving Court. So it's an evidence-based system that is really quite unique, and it has the complete and unqualified support from all judges that I have come across, from the Lady Chief Justice through the last President of the Family Division to the current President of the Family Division. And also what's particularly struck me is that although the number of judges doing FDAC is necessarily limited, there's no us and them in it at the moment. That the situation is that FDAC judges work alongside judges who do not do FDAC, and the non-FDAC judges, if anything, a large number of them would both want to and be highly suitable to be working in FDAC if the opportunity arose. Other advantages are the excellent underpinning theoretically and in terms of data and presentation that the Centre for Justice Innovation provides. It'll have been apparent from the presentations that you've seen that not only does that give us a very firm handle on what is going on, but also an ability to present it in a persuasive and objective manner. And CJI also is involved in supporting individual FDACs, training judges, and the like, and is completely integral to the way that matters are currently approached. But at the moment, the picture, as you've gathered, is that FDAC is continuing. It's, I would say, clinging on stubbornly, but its numbers are endangered because of the very understandable but regrettable in some ways short-termism that characterizes the responsibilities of budget holders. Also, we face arguments sometimes about whether this money that could be spent on FDAC might be better spent earlier in the process. I would suggest that rather misses out on the leverage that judges can bring, not only to the family that's before it, but to the same family that would have reappeared, the children that would have reappeared in the court, and the example that FDAC offers. There is an environment where we are being limited by the pressures that are felt by budget holders who have to look to compulsory services first. I'm quite clear that the approach for the future from the judicial point of view is that champions of courts in the areas that exist, the areas which would like and are coming up to getting an FDAC, hopefully, champions of courts which are under risk of closure because the local authority doesn't feel able to continue. Those champions are necessary. And we do everything that we possibly can to support those courts, but it's not sufficient. The future of FDAC obviously doesn't lie in an area by area approach. If it's to achieve its potential for the families and for the community in terms of financial savings, in terms of human capital, there's a need for a decision to be taken at central government level. And that is, in our democracy, that's a matter for government to decide. But from the point of view of the courts, FDAC is provided by one of the parties that appears before the court, the local authority. And so the future seems to me to be that if government was to decide that this is a good use of public money, then it has to be done in partnership with local authorities, not giving local authorities all the money to do it, but helping local authorities in a partnership spend, and one that is not limited to single year budgets. I'm extremely optimistic about FDAC for the future, and my thinking is more based upon the problems of success. That if a government does decide to accept the sort of data, the sort of recommendations, the analyses that we've been hearing about, then FDAC will move from being in a small area of the family court system to occupying a much larger space, and that will call for more judicial resource. A lot more judges will want to do it. Some will be able to, some will not be able to. There will be choices to be made. There will need to be some codification of a system that at the moment operates in an understood way, but not one that is found within the rules. There will need to be the sort of regulation and the sort of oversight that a mature system brings with it. But even if my optimism is not well-founded, it's my view that FDAC is a major force for good even now. The judges who work in FDAC they're not only satisfied but moved by the effects that can be achieved during the course of care proceedings. The course of care proceedings is often dead time, but it's not during FDAC, it's the whole point. And I see FDAC as being a beacon of good practice within ordinary care proceedings, because a lot of the judges who work in FDAC work in ordinary care proceedings. And I agree with Judith that there is an example. And so thank you very much for for allowing me those few minutes to express my own perspective of this. This is about new directions for FDAC, and I think the direction for FDAC should be forward. Thank you very much.
Thank you so much, Lord Justice Jackson, for your words and for your optimism for FDAC in the future. And that concludes our webinar on new directions for family drug and alcohol courts. I'm sure everyone will join me in thanking all of our speakers for sharing such powerful insights into the purpose, the benefits and the potential of problem-solving courts. I'd also like to thank everyone who's been involved in organising this event, particularly Bashar, who has coped so well with the technical side behind the scenes. And thank you to everyone who has attended today. I hope you found the event both interesting and thought-provoking. It just remains for me to say, on behalf of the Centre for Child and Family Justice Research, thank you all very much, and I hope you have a lovely evening. Goodbye.